Last year by Catherine Costello and Ezra Keitaz, which is in our protection, I always get confused even though I'm the editor-in-chief, it's the Legal and Protection Policy Research Series. The reason I get confused is because the section I head is called the Protection Policy and Legal Advice section, so we somehow inverted the name for the research series, but it existed prior to my time, so I take no responsibility for that. And Catherine and Ezra, a lawyer and anthropologist combined, looked at the perceptions of asylum seekers, and they asked asylum seekers why they comply with immigration rules. And in some ways this was to debunk the views held by some governments that asylum seekers, because they enter in an unauthorized manner or without prior authorization, are therefore not to be trusted. In fact, it came from a gap in the 2009 research that I conducted, which essentially I visited a number of alternatives, but I was unable in that research to engage with asylum seekers and others in the alternative. So it was a gap identified that we needed to fill on the perceptions of asylum seekers. And interestingly, Costello and Keitaz, they looked at a lot of this why general populations comply. It's got a very interesting theoretical part at the beginning and how much we have studied why the rest of us comply with the laws. You know, why do we comply with law? Why do we comply when we don't agree with the law, yet we still comply with the law, etc.? And they found that asylum seekers are just as law-abiding as the rest of us. And what they found, and they compared Toronto in Canada, the alternative system working there, and Geneva, Switzerland, one of the cantons there. And what they found that when persons are properly informed of their rights and duties, and that they understand what is expected of them, they generally comply with all formalities relating to their claim. And in the context of the Toronto shelter system, where persons are released from detention within a shelter arrangement run by non-governmental organisations, they find that people comply even up to the point of departure from the country when their claim has been finally rejected, because they've understood that they've gone through a fair process. There was a lot of sense in the groups that they spoke to in Toronto that they had trust in the Canadian immigration system. That was quite different in Geneva, where there was a general sense of distrust with the system. They didn't know what was happening to them, they weren't given appropriate information, and so on and so forth. They had a much lower return rate at the time when persons' cases had been finally rejected. But even in Geneva, they didn't have a high absconding rate during the asylum procedure. But they did have apprehension and uncertainty in the asylum seekers. That was kind of the difference. That the asylum seekers in Toronto knew what was going on, and asylum seekers in Geneva felt disconnected from the process, didn't know who to ask, etc., etc. The other point I wanted to make on compliance is that there are programs, we're going to hear about them today, where generally the cooperation rate, and by this I mean persons who, the absconding rate. In the Toronto bail program, they call it the lost client ratio, how many clients disappear from their program. And in fact, we generally see between 80 and 95% compliance rates. The higher compliance rates tend to be, and this is not necessarily scientific, but tend to be those programs that have contracts signed with the individuals, that they're expressly informed of their rights and obligations, as well as what the alternative will do for them. What are the obligations of the NGO or the other body to whom they've been released? In the Toronto bail program, they are required, for example, to report. They start reporting intensely, and then as they show that they are reporting consistently, this reporting stretches out. And also they're required to engage in meaningful activities. So they have this kind of dual component. Meaningful activities, working, taking vocational courses, education, etc. And that's an interesting thing from a social welfare perspective as well. The fifth is just a small word about cost. Grant and I were talking about the fact that some of our research on costs is dated, but nonetheless we are going to attempt to, governments seem quite willing to give us information about the costs of detention versus alternatives to detention and it might just be in the interim stage we get some updated data. But as an example, in the research from 2000, the Back to Basics studies from 2009, the saving for the the Toronto Bail Program, which is funded by the government, was 167 Canadian dollars per person per day. That's the saving. So if you take that over a year for one person, that's a saving of over 60,000 Canadian dollars. Around 60,000 Swiss francs, so 60,000 Australian dollars. I'm not sure what that is in US, maybe 55,000 US dollars. And I certainly can't say it in here. Many research indicates that there are kind of 5 basic ingredients to the success of an alternative to detention. Treating asylum seekers in dignity and humanity, treating them as people throughout the process. Provide them with clear and concise information about their rights and duties and the consequences for them if they, for instance, do not comply or abscond. Providing them with legal advice and access to legal services. Adequate material support is the 4th important thing, including opportunities for self-sufficiency, work, labour, employment, and education, etc. And 5 is this component of individualised coaching or case management, so that persons really know and can navigate the systems. But ultimately, most individuals do not need to have restrictions on their liberty. A system of appropriate reception arrangements where they can obtain relative and appropriate standards of care in many countries is the system that they have. And here I move on to some trends elsewhere, and of course we do see alternatives becoming more of interest to governments. We've also seen, of course, a rise in detention, so it's a little bit of a tension between growing detention rates but also growing interest in alternatives to detention. Of course, in Europe, the new recast directives now require governments in every individual case, if they're thinking of detention, to consider whether there are less invasive or less coercive means to achieve the same purpose. For example, reporting conditions where someone can appear to the police rather than be in detention. The European Migration Network is finalising its own research in this area. And we have many good examples of managing migration without recourse to detention or with limited recourse to detention, from Japan, Hong Kong, Thailand, Australia, the Netherlands, the UK, Belgium, Sweden, New Zealand, and the list is increasing. And I know you're going to hear from these examples, a few examples today, so I don't want to say anything else than to conclude by saying, from our perspective, moving to alternatives to detention makes sense. It makes logical sense. It makes political sense. No longer big compensation bills for detention, no longer court cases in relation to arbitrary detention. It makes sense from a practical perspective. It is possible to manage migration within the community, and it also assists if persons are in the end going to stay in the community in their integration. It allows asylum seekers to reside with their families, an important part of family reunification and stability in their lives. And all of this can be done taking into account security issues by governments, as well as the efficient operation of asylum and migration systems. In any event, just to say, it's very nice to be here. I look forward to your comments and to listening to your ideas, and my other colleagues will give you more practical views into how it works in their countries. Thank you.
תודה אליס על הסקירה המרתקת על חלופות למעצר ועל היתרונות הרבים שבחלופות האלה. אני אדבר פה בזמן שמחברים את המצגת הראשונה. הדובר הראשון שלנו שיעלה מיד הוא גרנט מיטשל. גרנט הוא המנהל של הקואליציה הבינלאומית שעוסקת במעצר, ה-International Detention Coalition. הוא עובד נמרצות יד ביד עם נציבות האו"ם לפליטים, לא רק בישראל, בעולם כולו, לקידום מודלים שונים לחלופות למעצר מבקשי מקלט ומהגרים. יש לו ניסיון עשיר מאוד בנושא, שהוא יחלוק איתנו את חלקו היום. וכמו שהוא יספר, אחרי ביקור ב50 מדינות שונות בעולם ובחינת המנגנונים הקיימים שם, באמת אי אפשר להתחרות בניסיון העשיר שיש בידיו. בבקשה, גרנט.
Hello everybody, it's great to be here. Thank you UNHCR very much for the invitation. This is my third time to Israel. I was here in 2013 with some of you. It's great to see you again. I was here in June as well. So I've had a chance to learn a little bit and understand a bit more about the context, the challenges here, the unique situation here in Israel, as well as to hear and kind of reflect on what that might mean for other country examples. Just to give you a bit of a background to myself, as was mentioned, I run an international NGO. We have members in 70 countries. A lot of our members are NGOs or service providers working in places of detention or providing alternatives. My background, I've worked on alternatives to detention programs and asylum programs in a number of countries. I worked in Sweden, the Swedish Migration Board is here. I worked there, as well as in Australia. I ran the largest alternative to detention program for asylum seekers. And since being in this job for the last 5 years, I've travelled to around 50 countries. So I've seen a lot of programs directly on the ground, really trying to understand how they work. And the challenges both that the government faces, but also the situation for people affected by detention. So today what I want to focus on is really just to look at some of those international examples, what's working in other countries, and to describe some of them as quickly as I can, and then to look at why some of those programs do work in the community, and then also the way that they're being implemented by governments. And thank you very much, Raul, for translating this into Hebrew. So thank you for that. So I'm just going to start just by building on what Alice was saying. I mean, we've seen a big shift in the last 20 years. A lot of countries are struggling to deal with irregular migrants or undocumented asylum seekers entering or on their territory. So we have seen detention increasingly used in the last 20 years. And of course, the situation in Israel, and my country, I'm from Australia, by the way, is the same in terms of the use of detention. But from a global perspective, we're seeing something quite different now. We're seeing states move away from detention in some cases as a first resort and starting to use alternatives. So the question is why? Why are they making this change? Alice touched on a couple of points. One is has detention been effective? Has it actually been effective as a deterrent for asylum seekers or irregular migrants arriving? And the research is no, it has not. And also the growing evidence that detention damages individuals, impacts on their human rights, but equally from a cost perspective, I mean, it's costly to individuals, but it's also costly to the government, as Alice was mentioning. I mean, up to 80% more expensive. But also what we're seeing as well is growing litigation against states in how they use detention. So we're seeing a lot of compensation cases around the world, and that is for a range of reasons, everything from wrongful detention, unlawful detention, negligent detention, prolonged detention, and so on. But the other reason that we're seeing a shift to alternatives is because they are actually being found to work and in the interest of the government and the individual. So that's why we're here today. So we're really here today just to look at how these alternatives work. We're not looking as much as at the detention system, but how alternatives can work in the interest of government. As Alice mentioned, there's been changes around the world. Europe is one such place. If you look at the European Union, there's been a massive increase since 2010 and 11, particularly in the last year and a half since then, on both the introduction of alternatives into law, particularly in Southern and Eastern Europe, but also implementing some new programs in how they're implemented nationally, and I'll be talking about some of those. So what we've done is we've gone to undertaken some research. We've looked specifically at 28 countries. We've added another 20 since then, looking at how alternatives work and function. We found more than 50 types of alternatives to detention. We didn't find one specific, perfect, holistic model that could apply for every country, for every type of arrival or person that could be affected by detention. We found instead a range of examples. And so these include the ways that governments don't detain, so the liberty or the release provisions, and that's everything from the way the court, the administrative decision-making processes or discretionary decisions to not detain, through to the types of status or provisional release mechanisms that exist. Secondly, we looked at the way states are managing individuals in the community, and I'm actually going to focus more on that in my presentation. And lastly, what conditions they might put on someone if they're not in detention. So in looking at all those 50 examples, we found two key themes that kept coming up. Some states were quite effective in managing people and reducing the use of detention, and they often had some type of screening or preventative mechanism. And secondly, the strategies they used to manage those cases. So for us, our primary question, and I guess a question here for Israel as well, is why is it that some countries don't use detention and they effectively manage someone in the community, and others assume you must detain them? So we wanted to bridge this gap and understand it further. So in doing that, we've created a framework, a model to pull together these types of examples that we looked at internationally. It's called the Community Assessment and Placement Model, which in Hebrew Rav has translated as, and it perfectly translates, doesn't it? Yes, that's wonderful. Some countries we find it doesn't perfectly translate. And basically it's the way that states can ensure detention is a last resort. So in line with international human rights standards, but also understanding the challenges of the state, that there may be concerns and they want to address those concerns, but ensure that people are not unnecessarily detained. So I'll just talk this through briefly. Steps 1 and 2 is very much how a state can prevent unnecessary detention. Steps 3 and 4 is how they can manage those cases in the community. And of course, step 5 would be detention only ever as a last resort. So I'm going to give some examples of what we found. I mean, the first step for states that had systems in place that we were looking at had a presumption against detention in law, which can also mean that there is time limits, restrictions on detention in law, and that there may be provisions or requirements to not detain certain vulnerable groups. So, for example, we noted in countries such as Finland, in New Zealand, that there was presumption against detention in law. We noted that in Argentina, that there was that migrants were generally not detained. The limitations on detention were so strong that it would only be for a migrant who has committed a crime, who is awaiting removal, serious crime, and it can only be for 10 days. So the majority of people, including asylum seekers, would not be detained. So in South Africa also, that has had very large numbers of asylum seekers enter their territory, also have a presumption against detention in law, so they will generally reside in the community. So a person would only generally be in detention in South Africa, an asylum seeker, if they didn't appear to their asylum hearing, for example, or their claim was found to be manifestly unfounded, or that they refused to comply. So others would generally not be detained. And we also have been looking at how certain vulnerable groups are not detained in different countries, and that includes women who are pregnant, nursing mothers, children, the elderly, those with disabilities, refugees, torture survivors. There's a range of categories that many states say we will not detain those populations at all. And if we just look at children for a second, there's a, and I know this has been a point of discussion here for some time, so I don't need to repeat it, but the impact of detention on children, both from a clinical perspective, but also in terms of their rights, is very clear. And the CRC, the Committee on the Rights of the Child, has been very explicit to states on this issue that states must immediately cease and end the detention of children. And it's been interesting to see the developments internationally. Oh, you've done it. Beautiful. You can think ahead of me. The different places globally that have moved away from detaining children, and we're going to hear from Belgium in particular today. The next thing we discovered was how states are identifying cases and being able to make more informed decisions. We discovered, in the next slide, we discovered that previously many states have made an assumption. If an asylum seeker came with no documents or an irregular migrant identified, they would assume the worst. They would assume they will disappear. We don't know this person, we must lock them up. We actually saw that states then end up in situations where they may detain someone unlawfully, wrongfully, unnecessarily. So we identified some states that have effective screening mechanisms to feel confident that they only would detain if there is an absolute risk. And those screening mechanisms help to make those informed decisions to determine where someone is best located in the community, or what supports they might be needed, and ensure detention is very much limited. So the 4 types of screening that we identified, and we're going to hear from the United States government, the person who developed the tool directly, so I won't go into it in detail, but it looks very much at what legal obligations a state has